We'll be talking about indefiniteness and functional claiming. So I think if the last panel dealt with a huge morass, perhaps we have two medium-sized morasses to get through today. I think it's appropriate that we're talking about indefiniteness before we get a ruling from the Supreme Court, since we don't actually know what it says and what it means quite yet. But we'll speculate as the last panel did. So let me introduce the panel. To my right is Dan Lang, who's Vice President of Intellectual Property at Cisco. He leads their team responsible for IP strategy, portfolio development, licensing standards, patent pools, and disputes. Before joining Cisco, I think in 2004, he was a partner at Ritter, Lang & Kaplan, and I think before that at Townsend & Townsend. He has a JD from Bolt, an MS from here at Stanford, and a BS from Case Western Reserve University. To his right is Drew Hirshfeld, who is Deputy Commissioner for Patent Examination Policy. He serves as the PTO's authority on examination rules and examination practice and procedure. He's had a very long and distinguished career at the PTO. He joined as an examiner in 1994. He's also served as the Chief of Staff of the PTO. He has a Bachelor of Science from the University of Vermont in Burlington, where I clerked, and a JD from the Western New England College of Law. And to my right is someone who will be familiar to a few people in the room. Mark Lemley is the William Newcomb Professor of Law at Stanford Law School. He directs the program in Law, Science, and Technology that's hosting this event. He has many, many publications and books. I think we'll probably have finished another one by the end of the day. He's also a practicing attorney, a founding partner of Dury Tungri LLP, and a founder and board member of Lex Machina, a patent data analytics startup. I don't have his education materials here, but I think he was an undergraduate here at Stanford, and I'm pretty sure he went to Berkeley Law with many of his colleagues at Dury Tungri. So with that, I'll turn first to indefiniteness and maybe just give a brief sense of my impression of the case, which is probably looking at it from a very different perspective of a lot of people here, and that EFF filed a brief supporting the petitioner. And we also were one of only two parties, two briefs supporting cert in the case. So we definitely think that indefiniteness is an issue worth addressing. The petitioner is arguing that if a claim is after construction, after all the tools of claim construction are exhausted, you still have two reasonable interpretations, and at that point the claim is not particular and distinct and should be held invalid. The Biosig, the respondent, with support from the Solicitor General, is arguing that the test should be something that's clear, reasonably clear to a person of skill in the art, and that's sufficient. The treatment of the Federal Circuit jurisprudence was quite interesting, both in the briefing and at the oral argument, in terms of people, the respondent and the Solicitor General, supporting affirmance, but at the same time running away from the insolubly ambiguous language of Exxon and data mines. With that, I'll ask the panel what their, perhaps quickly I'll give my impression of the oral argument. I think I was expecting more of a textualist approach and more discussion of the statute and less of a long and deep discussion of the technology at issue, given they're dealing with the standard for all cases, but the Supreme Court really dug in to the facts of the case. I think that was perhaps a bad sign for the petitioner, but I'll let the panel say what their impression. And just perhaps we should excuse Drew, given his position at the U.S. Patent Office, might not be able to answer all of these questions, and this might be one he has to sit out. But what were the impressions of the oral argument?
All right. Well, I'll start. I think Daniel's right that the argument probably didn't go as well for the petitioner as one might have thought going in. If you look at definiteness law from the outside going into this case, what you've got is a pattern which looks awfully familiar from the last decade, right? Which is there are a bunch of old Supreme Court cases that set out a legal standard. There is a federal circuit jurisprudence developed in the last 10 or 20 years that departs markedly from that standard in a way that is more patent friendly and less and more rules-based, less kind of case-by-case standards. And what has happened in every one of the cases that has gone to the Supreme Court that have that pattern is the Supreme Court has said, no, you can't have a specific patent rule that ignores prior Supreme Court precedent. The right test is the case-by-case multi-factor test that we articulated some time ago. Go back to that one. And so I went into the oral argument thinking that's what's going to happen. Right, the Supreme Court, which last heard an indefiniteness issue in the 1940s, phrases the standard in those cases as something along the lines of, could a reasonable scientist who picked up this claim know whether or not they were infringing it? Right? Would they understand what was inside the scope of the claim and what's outside the scope of the claim? That's very different than the standard the Federal Circuit has been articulating in the last 10 years, which is after lawyers get to the thing and do everything they can do with claim construction to try to figure out the meaning of the things, is the term nonetheless insolubly ambiguous? Could lawyers with all the tools at their disposal simply not figure out a meaning for the term? And then and only then it's indefinite. So you might think, well, Supreme Court's going to say, no, we meant what we said in the 1940s. What's interesting, I think, is that while there is very little reason to believe that the Federal Circuit's insolubly ambiguous test is going to survive, the court was clearly looking for something that was a lot less dramatic than what the petitioner was asking for. What the petitioner said was, the rule ought to be, if there are two reasonable constructions of this term, then I can't pick this up and look at it and know whether I'm infringing or not, and therefore it's indefinite. And I think the court looked at that and quite correctly concluded that if that's the test, there are not many valid patents in the country, right? Anyone who's done litigation knows that the goal of claim construction is to identify ambiguities even in words that seem to lack them, and many of those positions, right or wrong, are reasonable. And so if the test is, can lawyers come up with arguments on both sides of this issue, not many patents will survive. So they seemed, I think, on the legal merits to be gravitating towards some kind of middle ground, maybe the middle ground articulated by the Solicitor General that was based on, could a person of ordinary skill in the art understand this with some help? And they also seemed, I think, unpersuaded by the petitioner's claims that the particular invention in this case, which had to do with where you put the electrodes on an exercise machine to try to measure heart rate from each of the two hands, that there really was much ambiguity or uncertainty associated with the terms at issue in that case.
So, first I should mention that we supported the petitioner in this case, but, hearing about how the oral argument went and how a lot of it did actually focus on the claims themselves and what they meant and the technology and the spacing of the electrodes, et cetera, it kind of brought to mind the fact that if you'd asked me a couple years ago, what is the ideal case to go to the Supreme Court on this issue, I probably wouldn't have thought it to be in a technology like exercise equipment or in some sort of mechanical arrangement of things. I was thinking of more the kind of patents we see, more software, more IT oriented, that are indefinite and unclear for other reasons. And my fear, in hearing Mark and Daniel explain the flow of the oral arguments, is that the standard that they managed to articulate at the end of this, although it's not going to be, quote unquote, insolubly ambiguous anymore, it's going to be something that isn't going to have enough impact to solve the real world problems that we focus on in this industry. And just to outline, what the situation is that we're dealing with. I mean, at Cisco at any one time we have 65 to 70 litigations going on at once. To walk back from that. To this issue, there's an impact to the current state of indefiniteness law on drafting, on the patent marketplace, on enforcement, and then ultimately in the litigation that we're subject to. Just at the drafting stage, a good drafter is faced with a tension of, that we have limited budgets for patent drafting in our industry. It's become more expensive since I started doing this to add claims. So there's always going to be a tension between writing a claim that clearly covers in a very crisp, definite way what's actually been invented in the here and now, or on the other hand, using more ambiguous, more flowery language that's going to capture what's going to happen in the future. I mean, there's probably a middle ground where you get at what's been invented and logical evolution of it without being so grabby and so unclear as to be able to grab things in the future that don't really connect with what you've invented in the present. So I think that right now the incentives point to drafting that clearly, because you're at relatively low risk of losing your claim in the future for indefiniteness. So why not be opportunistic and try to grab as much as what's going to happen a long time from now, and or even nearer to now, things that you didn't actually invent. And then it just flows on. I mean, and when patents are sold or licensed, I mean, there's an opportunism. I mean, there's the ability to assert patents against things that do not relate to the actual invention because of the ability to put forward ambitious claim interpretations and not worry about creating the impression of ambiguity, and then the ability to sue people on those patents. And that's it's not everything that's driving the wave of patent litigation from non-practicing entities, but it's a strong contributing factor. So I'm hoping that we end up a little bit better than, or actually a lot better than what the oral argument seemed like. I mean, I recognize that for a standard to be used in litigation, it's not going to just be that there's two possible reasonable interpretations, because I agree with Mark that the lawyers can always produce language that or produce issues about language and cause there to be an ambiguity, even if there is none to a normal person. But nonetheless, we need to focus on, is the patent really giving the public notice? Can someone of ordinary skill in the art look at the claims and look at the spec and readily figure out what's inside the patent, what's covered by the patent, and what's not? If there is more than one reasonable interpretation, is the specification itself going to help you significantly get to the answer in a clear way? I mean, if there are claim terms that have no meaning and the specification doesn't define them, I think that claim should die. So I think there's some useful guidelines that are sensible middle grounds that the court could adopt. We'll see what they actually do.
Let me just throw one thing in there. I do think one of the things you see play out in the oral argument is related to what Dan's talking about, right? Which is the kind of interplay between clarity of the claim and breadth of the claim, right? So we're going to talk later on in this panel about functional claiming, but I think the way the petitioner, the way the respondent, the patent owner reads this claim is to say, you know what? Where do we put the electrodes? We put them sufficiently far apart that they don't interfere with each other. And how far apart is that? You try it and you find out. You work it and see, and anything that works basically is the definition they give. And I think the court's reaction to that is, well, that seems like not really much of an invention. Maybe the claim is overbroad, but I don't know that it's indefinite, right? If I'm really claiming the universe, anything that solves this problem, I might be quite clear that I'm writing this overbroad claim. We might not want to allow it for other reasons, and some of those other reasons about functional claiming we have put into the indefiniteness category, and we'll talk about that, I think, later on. But there is functionality, and functional claiming is popping up in this case because of the way the patentee has interpreted the claim.
Dan's comment about claims not being defined in the specification made me think of the PTO's pilot program for glossaries. So perhaps that would be a good segue briefly before we return to indefiniteness, a question Drew can address about what's going on and, at the PTO to clarify claim
Sure.
terms.
I'm happy to address the glossary program. I'd like to address it in the context of some further thoughts that I have about the Nautilus case, specifically something that was pointed out in the government's brief. And that case, the Nautilus case, is really about what standards the courts should apply. And it's not necessarily going to address or impact the standards that are applied at the PTO. And in the government's brief, there was an acknowledgement that they should be different standards. So while the PTO, while you're in front of the PTO and you don't have a patented claim, you have a lower standard of what's ambiguous so that more rejections would be made, and hopefully you're clarifying issues while the applicant has a chance to amend. And then for an issued patent, the standard would be slightly higher, so that you wouldn't necessarily, when they don't have the chance to amend, you have a different standard. That does lead me to the glossary pilot program, which is one of many initiatives that we have going on at USPTO to try to improve the clarity of our examination and issued patents, so that we're doing the right, getting the right scope of claim and getting that notice function properly addressed during the application stage, so that these aren't issues once a patent does issue. The glossary program stemmed out of White House executive action items. You're probably all familiar with them. One of the executive actions was for PTO to tighten its scrutiny of functional claim language, and we'll talk about that more shortly. And one of the ideas that was addressed in the executive action was the idea of using a glossary pilot program to test the effectiveness of glossaries. So starting at the beginning of June, very shortly, we will be accepting people into a glossary pilot program, which we really have structured very broadly. We intentionally left it broad. We actually had a software roundtable on this exact issue about the glossary program, and there was feedback on all sides. Some believe it would be very helpful, others believe it would not be helpful. So we purposely left it broad to give applicants the freedom to use glossaries any way they see fit. And we will use that feedback and the use of glossaries to be able to evaluate, does this make an improvement? Is this a helpful next step forward? In return for helping us evaluate the effectiveness of glossaries, we are giving applicants an expedited office action for the first office action. So trying to entice people to use this and work with us and see the effectiveness of a glossary program.
So I am all in favor of anything that gives us more notice and certainty early on about what it is that the patent claims cover, and so I think the glossary program is a good idea. But I want to caution you that this is not a panacea. And I think that's true for a couple of reasons. One is many of the cases that present indefiniteness issues don't present them because you used a term and no one knows what it means, or scientists have two different meanings for it. It's because you used terms that themselves don't actually give us the information we might want. So in Nautilus, the claim language is spaced apart. And the question is, how far apart is spaced apart? It's conceivable, I suppose, you could define spaced apart in a glossary in ways that said 3 centimeters or more, but if you were going to do that, you ought to just write a claim that said 3 centimeters or more. Other cases have involved things like so dimensioned as to fit in a particular space. And these things, I think, just aren't going to be solvable by the glossary problem. The second problem, which I think, frankly, is just a more fundamental issue with claim construction and our system of trying to define inventions with respect to words, is that if we do claim construction and we have the definiteness doctrine because we think the words that are written by the patent lawyer are not very good at explaining what it is that you have covered and not covered in the scope of your patent, replacing those unclear words with other theoretically clearer words does not always get us where we want to go. And anybody who's done litigation knows that once you do claim construction in court, particularly if you divorce it from the substantive outcomes of the briefing and summary judgment, the very next thing that happens is the lawyers come back and they fight about the meaning of the terms we have used to define the terms that we didn't understand in the first place, because those terms are often not any clearer. So none of this is to say we shouldn't try to nail it down as much as possible, that we can't help get towards clarity. But I do think part of the problem is irreducible, right? That is, we are going to have ambiguity as long as what we're doing is not looking at what it is the patentee invented, right, what they actually made, but at the words the lawyers wrote to try to define a parameter around what those inventors made.
Yeah, so I agree with what Mark is saying, right? I don't think that this is a panacea, but I do believe that it should be evaluated, and any improvement is good. I can tell you as a former examiner, the issues that we would fight or argue over with applicants about definitions were usually those simple words like end or top, right? What do you mean by that? Not those very technical words which have a much more defined meaning. Mark's feedback is very consistent with feedback we received. As a matter of fact, we had feedback on all sides of this. There's people that believe that this will be a great help, and there's others that have concerns. And our approach is, let's test it and let's see, and if we can make improvements there and make improvements other places, we will all be better off for that.
So I mean, I agree with Mark that part of the problem may well be irreducible, but I still believe that there's a very important reason to try very hard to solve it, and you maximize the ability of the system to police this problem. And I went over earlier sort of the operational concerns and how the present regime is distorting the preparation of patent applications and as well as their enforcement and transactions. But there's also, from where I sit, a very important reputational concern for the patent system as a whole. Right now, when we put patents in front of technical people or business people, as we often have to do, there's really a kind of an abhorrent reaction in many cases that I'm an expert. I'm an expert in this technology. I can't figure out what this means, and we have to tell them that, well, we can figure out what it means. It's just going to take us, several $1 million, maybe a layer or two of appellate review to get to that. And, that I think, like, some of the issues that we were talking about earlier today, and as well as, maybe it's, setting the correct bar on obviousness and, other aspects of operation of the patent litigation system, mean that the patent system as a whole, has a low reputation among the people who, in theory, should be its main customers, people who are innovating and investing in innovation. So, but the point of that is that we need to come out with, I hope we will come out with a standard from Nautilus and perhaps its progeny, as whatever comes out in Nautilus is further elucidated, a standard that means that people who are skilled in the art can read patents and have a pretty damn good sense of what they actually mean. If we tell them that it's going to require a lot of litigation about what the file history means, or numerous expert declarations back and forth, that's not a satisfactory outcome. We should be able to figure out what the patent means by basically reading the claims and reading the spec. I mean, that's what it comes down to. And if we can't do that, I think in a way that we failed.
So, jumping off from that, I wonder what we expect and what we would like from the Supreme Court and Nautilus. I was really struck by, I think it was Justice Scalia's remark at some point where he's like, I thought we took this case because of some really extravagant language from the Federal Circuit. And the sense I got was they really don't like the insolubly ambiguous language, but overall the argument went better for the respondent, and they seemed relatively happy with what the Solicitor General was saying. But in that case, do they remand? Do they go back and line edit, like the Exxon opinion? It doesn't sort of procedurally. I'm curious about exactly what they can do to hopefully make the world significantly better. But even if they don't agree with exactly what the petitioner was saying.
Yeah, so I mean, I do think the most likely outcome is that the court rejects the insolubly ambiguous test, but also rejects the if there are two possible interpretations, then the claim must be thrown out. And the most likely candidate for a verbal phrase around this is something based on the person having ordinary skill in the art, right? Could the person having ordinary skill in the art figure out what this means? And I think then there's going to be some sort of weasel word associated with figure out what it means. That is, it must not be completely clear to them, right? If it's completely clear to them, you're back to the petitioner's test, and as long as there are two different reasonable interpretations, we'd throw the claim out. So it's going to start to sound more like our enablement doctrine, right? Could the person having ordinary skill in the art figure out what this means kind of without undue experimentation? Now, I mean, I think the real issues around that have to do, well, there are a couple, right? One is we don't really mean entirely the person having ordinary skill in the art. We really mean the person having ordinary skill in the art with some accepted canons of legal interpretation thrown in. If you go ask a geneticist what's the difference between comprising and consisting of, unless they've filed a lot of patent applications, they will have no idea what you're talking about, right? So we're clearly going to build into our I read this claim, what does it mean? Some baseline level of knowledge about patent law, right? That says a confusion that a scientist might experience because they don't know the difference between comprising and consisting of, that can't count, right? And then I think the question becomes, you know, what happens if the answer is a person of reasonable skill in the art could figure it out, but they might get it wrong, right? That is, what happens if our claim construction turns out to differ from what a reasonable person might have concluded? And one thing you could imagine happening, although I don't think the court is going to go this way, is to say, well, you know, if you actually read this patent and you reasonably concluded that it meant X and you changed your behavior accordingly, right? I designed around what I thought the patent covered, that you'd end up with some sort of safe harbor, right? That it's not that we'd invalidate the patent, but that it would be a defense of some kind for me to say, I read this patent and I tried my best to comply with the law, right? That's probably a good idea as a policy matter. It's not going to happen in this case, and probably wouldn't happen without some sort of statutory change, because we make patent infringement a strict liability offense. But I mean, the problem I have with this person of skill in the art formulation that the government offered as a compromise is, I don't see how it doesn't reduce back down to either two reasonable interpretations or some version of insolubly ambiguous. That is, we either sort of say, well, a person of skill in the art couldn't figure it out because they could have gone either of these two ways and we don't know which one is right, or they would say, person of skill in the art can figure out an interpretation, and as long as they can figure out an interpretation, the patent claim is not invalid. I think we're going to see a different formulation. I think we're going to see some language that signals that the right answer to when our claim's indefinite is not almost never, which is the Federal Circuit's answer. But I don't know that we're going to get a lot more conceptually useful guidance as to when those additional cases ought to happen.
Drew probably has to sit this one out, but...
I have to obviously sit out where I think the court is going to go, because it's a pending case, and obviously I work for the government. But I can talk about the government's brief, and while the government argued that insolubly ambiguous and not amenable to construction is not the right standard, they argued that because it was felt that that could be misapplied by others, right? But the government also seemed to say that the Federal Circuit had been looking at those phrases while taking into account what one of skill in the art would have done. So it was a way to say, we believe the Federal Circuit is looking at this for the most part based on what one of skill in the art would feel, and we're concerned that people can misapply the insolubly ambiguous test. So I think that was the basis for trying to move away from it.
Yeah, I mean, I recognize that there's going to be a struggle to get to a conceptual framework, and maybe the best that can be done within a sensible conceptual framework is to have some rules of thumb that make sense. I mean, one of them was the one I advanced earlier, that if there are claim terms that are undefined in the art, they need to be defined in the spec. I mean, that I agree that maybe only get you to 15% of the whole problem, but it'll help. I also think that if there are two interpretations that are of roughly equal plausibility and would have been seen as equally plausible to the drafter, that's something that should also be policed. I mean, maybe we need to also enforce some discipline about what's objectively reasonable for a drafter to do in terms of anticipating the problems with his or her claims and adjusting them at the time that the application is being filed. If there are two interpretations that are apparent that are of greatly different scope, I mean, that's another thing that I think you can hit back against explicitly. And I bet you that there's, if we go through a pile of examples of patents, we could probably come up with 3 or 4 or even 5 more rules that would put some flesh on the bone.
I think some have suggested avoidably ambiguous to sort of put the pressure on the applicant to draft as clearly as possible. But again, not sure that would be any easier to apply in practice. So speaking of putting the pressure on the applicant, perhaps we can speak briefly about In re Packard, which was decided, I think, last week or earlier this month, where the Federal Circuit, I think it was Judge Plager, ruled.
The court was per curiam, and then Judge Plager wrote a very long concurrence.
That's right. And the per curiam opinion basically establishes a different standard pre-issuance, and on my reading, upholds the PTO's practice of their authority to just say this isn't clear enough, and you've got to come back and either clarify it, explain why in fact I'm wrong and it is clear, or otherwise we can issue a rejection. So I wonder, is there a really significant difference between how these issues should be looked at before and after issuance? But perhaps first ask your impression of the case and what it means for the PTO.
So this case is rather straightforward technology. It's a coin change holder, and the issue really in front of the court here, unlike Nautilus, was what standards should the PTO apply for indefiniteness? And basically what the court had determined, let me back up a little bit. During prosecution, the examiner had made a number of rejections based on the claims being indefinite. Those were never really fully responded to. I believe the case went to the board, and the board maintained those rejections, and then the case ended up in court, and it was decided that when the PTO has a well-grounded rejection, an applicant fails to provide a suitable response, that PTO is justified and should be maintaining that rejection. So to answer one of your questions, does this indicate a change for PTO? I don't think this indicates a change for PTO. I think it affirms that what our examiners are doing is correct, that they should be policing maybe the gatekeepers of indefinite language and should be maintaining those rejections where they feel they don't have a response. We'll get into some claim clarity in what we're doing at PTO shortly, but we are trying to teach all of our examiners that, hey, this is a very important function. We need to be very clear on the record, and you have concerns of a claim, you should be making those rejections. So I don't see this as a big change. What it also highlights, and I believe this is the second part of your question, is the standard being different, and I mentioned this before, about claims being in front of the USPTO where there can be amendments, and that there's a lower bar to what's ambiguous, so that you are catching, hopefully, more of the indefiniteness problems during examination, getting those out of the way when applicant can amend, and then I believe once an issued patent, or once a patent issues, those claims could be looked at and are looked at currently with a different standard, a higher standard than the one at the PTO.
So I want to let me say just a little bit about kind of the substantive standard and what the court actually says, and then maybe raise the issue of this different standards between prosecution and litigation. So the language of the court is quite interesting, and I could conceivably be a template for the Nautilus case, even though the court says these happen in different circumstances, right? So the court's test is a reasonable precision test. The requirement, the court says, is not a demand for unreasonable precision. The requirement applied to the real world of modern technology does not contemplate in every case a verbal precision of the kind found in mathematics, nor could it do so. Rather, how much clarity is required necessarily invokes some standard of reasonable precision in the use of language in the context of circumstances. If the claims, read in light of the specifications, reasonably apprise those skilled in the art, both of the utilization and scope of the invention, and if the language is as precise as the subject matter permits, the courts can demand no more. So that's a kind of, reasonableness plus person of skill in the art test, which is while it's articulated in this very different context, right, is not all that different than what we were talking about as a possible test we might see come out of Nautilus. I also don't think that it's terribly precise. I'm not sure that I can take that test and say, aha, now I know what claims are definite and which ones are indefinite. But the court goes on to do something else, which I think is quite interesting, which is to strongly emphasize the importance of the patent office actually doing this in the examination process. So the court says the USPTO, in examining an application, is obliged to test the claims for reasonable position according to these principles. We have recognized the importance of the role the USPTO can play in ensuring that patent claims are clear and unambiguous. And they cite to two other cases in which the court has said an essential purpose of patent examination is to fashion claims that are precise, clear, correct, and unambiguous. Only in this way can uncertainties of claim scope be removed. And another case, Halliburton, where they say the patent drafter is in the best position to resolve the ambiguity in the patent claims, and it's highly desirable that patent examiners demand that applicants do so in appropriate circumstances, so that the patent can be amended during prosecution rather than attempting to resolve the ambiguity in litigation. And I think that distinction is what justifies the court in saying, as it does, the standard when it comes up from the PTO is different than the standard in litigation. If you're in litigation, you've got an issued patent, the only thing you can do is throw the patent out altogether, the patent claim out altogether, or say, no, it's valid. Right? The PTO has a third option. They can say, I don't understand what this means, clarify. And that's what they did in Packard, right? And if you say, the PTO says, I don't understand what this means, clarify, and the applicant chooses not to clarify, then it's perfectly appropriate under Packard for the PTO to reject. So I think logically, it makes perfect sense to say we ought to impose a higher standard at the PTO than at the district court, because the applicant has an easy response at the PTO, right? They can amend their claims and make them clear, or they can explain to the examiner why they think they're already clear to a person of skill in the art. The problem is there's nothing in the statute that suggests that there's any difference in the legal standards of definiteness that we're going to apply in these contexts. Judge Plager's concurrence goes on to talk about some of the arguments that Packard made on appeal, and part of the argument, one of the issues that comes up there and that people have articulated from time to time for reasons to justify this difference is the presumption of validity. Right? The clear and convincing evidence standard would apply to issued patents. The problem with that argument is that, at least right now, under the Federal Circuit precedent, indefiniteness is a pure question of law. And it seems pretty clear, I think, that clear and convincing evidence standard doesn't have any applicability to pure questions of law. It's about evidence that's presented, not legal interpretation of terms, right? And we don't defer to the patentee's interpretation in claim construction, for instance, right? Because we don't think that's evidence in the relevant sense. So, I guess the question is whether we could get to this distinction, which I do think makes sense, through some kind of Chevron-style deference to the PTO's interpretation of definiteness, coupled with the PTO saying, but this is good only in the patent office. And that would be, we probably ought to bring John Duffy back up to this panel to talk about the administrative law implications of this. It would be odd, I think, but to say, well, we're gonna let the PTO define this legal term differently than courts do it, where they tell us that they're going to do it, and where they say, but we only want that to apply in our context, not in the judicial proceedings, but maybe it's permissible.
Well, I'm happy with the decision here. I want the PTO to do more than it's been doing in this area to reject indefinite claims. I mean, as I was saying earlier, I mean, there needs to be a stronger incentive on the drafter, and then I alluded to the risk of invalidation later in enforcement, but a more efficient way to getting into that incentive is for the PTO to directly confront the applicant with the ambiguity of his or her claims and force them to change it right there and then. So it's a good thing that there can be a different standard in the PTO than there is in court, because for the reasons that we discussed earlier, the courts are not going to have such a strict standard of rejecting claims for having for example, two reasonable interpretations a la Miyazaki, whereas in the PTO, there's just a different cost-benefit trade-off. We're not killing patents. We're just forcing the applicant to restate them in a way that's better. I hear the concern about what's in the statute actually, and how do we get from what's in the statute. I'm glad that the Federal Circuit feels confident that they've solved that problem, even if I'm not necessarily the best one to articulate what the solution is. It seems to me that for the PTO to do its job in setting the other standards of patentability, like obviousness and anticipation, it needs some leeway. Maybe that goes further than the statute on definiteness. I mean, it's just simply as a practical matter to fulfill its duty to evaluate the novelty and non-obviousness of patents. It's going to have to go further, perhaps, than the statute might be interpreted in a judicial context to be able to do its job.
Great. Perhaps with that, we can turn to functional claiming, since about half our time remains. Just to do a quick survey of the land, particularly from a Stanford and perhaps Mike Lemley centric perspective. We had Mark's paper come out on SSRN in 2012. I'm not sure when its actual formal publication date is, although that kind of thing matters a lot less these days. And in June of last year, President Obama issued an executive order directing the PTO to tighten up functional claiming. And of course, that's great, and we were at EFF, we were really encouraged by that, but the PTO, of course, is bound by Federal Circuit law, and they did issue some guidance and examiner trainings that I personally at EFF we were pretty disappointed with. I'm not to criticize the PTO so much as just like it certainly didn't change things in the way that Mark's paper suggested things should be changed, and seem to in the software and high-tech world allow a lot of words not to be construed as functional claiming, configured to, computer configured to, processor configured to is not necessarily going to be treated as a means plus function claim. And I then very recently, again, we had the Federal Circuit in Apple v. Motorola. Basically, I would read it as well, it's pretty clear given that the dissent cites Mark's paper and the majority rejects the view that there really needs to be a change in how we think about claims the way claims are drafted and the focus on magic words rather than how technology really works and is being claimed. It's obviously slightly biased perspective there. But with that sort of EFF introduction, I'll turn to Mark to say, how did you?
Well, it might be useful to give a little bit of background here because we've sort of wandered into a new area. So the legal question here involves Section 112F of the statute, right? So not directly indefiniteness, although indirectly, as we'll see. Section 112F is designed to get at functional claiming. So once we started allowing claims to cover, sort of to be defined by define the boundaries of the invention in the late 19th century, people started writing claim language that was broader and broader. I didn't want a patent on this machine, right? I wanted a patent on any machine that performed this function. And so we had a bunch of cases in the 1940s where you wrote patent claims to, machines that are designed to achieve this result. And the Supreme Court got fed up with that and said, no, you can't have that, right? This is not an actually permissible way of defining the patent claim. Congress in the 1952 Act struck a compromise. They said, we will not allow you to simply claim things in functional terms, anything without structure that performs the function, but we will allow you to write your claim language in functional terms without using structure, and that'll be a signal that, unlike the rest of patent law, we're going to go read your patent specification, find the structure that corresponds to those functions, and limit your patent claim to that structure and equivalence thereof. And so this is what's now known as means plus function claiming, because one common way to signal that you are doing this thing is not to actually describe structure, but to say means for processing data. And I know that's a signal that I don't include my brain or pencil and paper or any possible means for processing data. I include the means for processing data that are disclosed in the specification and equivalence thereof. So, what's happened in the software world is people have increasingly been writing claims that are purely functional, but which don't use the magic words means for doing X. So I write claims in the form a processor configured to achieve this result, or even a processor configurable to achieve this result, right? The literal scope of that claim language, if we don't treat it as a means plus function claim, is any program in any computer that happens to achieve the result, right? I'm claiming the function, I'm not actually claiming any particular structure. At the same time, the Federal Circuit has said, has allowed a number of these claims, and Apple versus Motorola, which I'll talk about in a minute, is one example of that. At the same time, the Federal Circuit has also said, if you do use means plus function claiming, if you do invoke Section 112F in a software claim, the structure you have to show me is a computer program, a computer algorithm. It's not sufficient to say, here's some computer hardware, and any computer program of any type that achieves this result loaded in that hardware will qualify under my patent. The structure of a software claim has to be its algorithm. And if you don't have an algorithm at all, if you write a means plus function claim, but it has no algorithmic structure disclosed in the specification, it is invalid as indefinite, because we don't know what algorithms that claim is supposed to cover. So the result has been that there's a very high premium on the decision whether or not we're going to treat a computer program claim as a means plus function claim or not. The Federal Circuit has been pretty formalist on this question, so they don't exactly say if it uses the magic words means for doing X, it's means plus function and not otherwise, but they have been coming increasingly close over the last 20 years to saying that, because the Federal Circuit likes bright line rules, right? It's not what the statute says. What the statute says is if you don't have structure in your claim, you just have the function, it's a means plus function claim. But what the Federal Circuit says is, if it doesn't use the magic word means, it's probably not a means plus function claim. So that brings us to Apple versus Motorola. In Apple versus Motorola, the patent claim is to a heuristic. and a heuristic that figures something out. Doesn't tell us what the heuristic is. It's a heuristic that figures something out. Motorola says, well, that's a means plus function claim element. You haven't given me a structure. You haven't given me the algorithm, the actual heuristic for figuring things out. You've just said, use a heuristic to figure this out. Curiously, the majority says, doesn't use the magic word means, so it's not a means plus function claim. But then the majority goes on to say, and we think there's structure in this claim because we're going to define the word heuristic as having all of these algorithmic elements that are listed in the patent specification itself. So they redefine the term heuristic as limited to all of these things in the patent specification, and then say, and therefore it's not a means plus function claim, there's structure in that claim. The dissent says that doesn't make any sense. The patent claim as it's written, the word heuristic, that doesn't give me any structure. It doesn't give me an algorithm. We ought to use the statutory tools, means plus function, and go look for the structure in that context. Now, I think the majority in dissent also disagree as to whether those algorithms disclosed are enough. Whether what's in the Apple patent is actually sufficient to qualify as a real algorithm. But what's curious about it is, while the court sort of rejects the idea that just saying some program that achieves this goal triggers means plus function claiming, they end up kind of bringing in through the back door some of the same results in means plus function claiming, because they go read the specification and end up using that specification to limit the patent claim in a way that you would have otherwise thought was inappropriate.
Well, I have to confess that I found the majority opinion in the Motorola v. Apple case pretty confusing and hard to follow the reasoning of. I came up as a patent drafter in the sort of the late 90s and early 2000s, and indeed, I think we were trained to think that this section 112, and that was paragraph 6, not section F, of course, was something that you chose to invoke. If you had an extra, if you had the budget and time to draft an extra claim, maybe you'll put a means plus function claim because it'll be a little bit different. It's gonna pull in the spec and some unpredictable range of equivalence. And it's a neat little drafting trick that you can use. You probably don't want. I think we were shifting away then from the notion of being being able to just use those claims very broadly. You are going to have to go back to the spec for the structure, but nonetheless, it was your choice as a drafter. Whereas I think Mark, with his paper, quite properly reminded us all that there's actually a policy reason that this language is there in the statute, and we've totally, we had totally forgotten it. And the policy reason has to do with limiting unreasonable patent claim scope and results-based claiming. And that results-based claiming, I think, is very related to what we were talking before about indefiniteness. It relates to the ability to morph claims and to assert them against things that they weren't intended to cover, both in terms of licensing and enforcement. And it also contributes to the reputational concerns that the patent system has, where people read patents and somebody will you put a patent that was drafted 15 years ago in front of a subject matter expert of today, and they're completely mystified as to how anybody could think that what they were talking about back then relates to what I'm doing now. And this is one of the things that should get fixed. Like Daniel, we were hoping perhaps unrealistically for the PTO's functional claiming guidance to go further in solving this problem, but I think the rationale that they advanced for not going further, which is that the judicial backup wasn't there, has now sadly proven to be correct in terms of what what this decision has provided us.
So let me say a little bit maybe about how this applies to the biotech world. I'm sorry.
No, I'm good. I do definitely need to address what we've done at PTO on the guidance, but
go ahead.
No, you go first. I will come back to it.
All right. So let me actually tie this to biotech, since we are at a Biosciences Conference, and we haven't done a lot of that yet on this panel. So I think the kind of claiming we see in software is claiming that we just wouldn't really see in the biotech world, and if we did see it, people would say, no, that's crazy, right? So to me, claiming a computer configurable to achieve this result is basically the same as claiming atoms configured to cure cancer. Right? I claim I've figured out a particular drug which treats cancer, and I claim, you know, any arrangement of atoms into a molecular structure that has that same effect. And look, I've shown you one, but I don't want to be limited to one. I want to claim all of them. And I can understand why you'd want that, but I think if you walked into either the PTO or the courts with that claim in the biotech world, they'd say, of course you can't have that. Right? Now, we do allow some sorts of functional claiming in the biotech world. And so I think one of the interesting issues around functional claiming is it can sometimes be a tool for allowing us to identify and define things that we cannot otherwise fully specify. So we see this most commonly, I think, in the context of antibodies. Right? It's relatively common in the biotech world, for instance, to characterize an antibody by the antigen to which it binds, coupled with some evidence of the affinity and the specificity. Right? So, but I think that there's something different going on there. Right? That is. You could read those claims and say, what I mean by that claim is anything that ever binds to this antigen, regardless of where it binds, regardless of how strongly it binds, and so forth. And if you write the patent claim and you understand it to have that meaning, then it starts to sound more like these software claims. But that's not how the Federal Circuit has interpreted those claims. When you write claims to an antibody using the antigen characteristics, what the court has said you're using that basically as an effort to define a class of antibodies you have in fact identified and you simply can't characterize by normal structural chemical methods. So in the In re Biogen IDEC case, for instance, the patent claim is to an anti-CD20 antibody. The patentees come up with a particular one, Rituxan, and the PTO says, well, but you can't just have anything that might bind to the CD20, right? Because you haven't shown us all of the possible chemicals that might bind to CD20, and the patent applicant says, well, no, what we're claiming really is Rituxan and things that bind the same way as Rituxan, that have the same affinity, the same specificity, and that claim's allowable. But the Federal Circuit says, even though the actual claim language is anti-CD20 antibody, right? It's defined purely functionally. We're going to interpret that language as being limited to the actual ones you disclosed and things that work like the actual ones you disclosed, right? They don't expressly invoke 112F, but it sounds like they're doing basically the same thing, right? I'm saying, here's the example you gave us and ones that are equivalent to it, ones that serve the same purpose. And we see something similar in product by process claims, right? Sometimes I write my claim in product by process forms, the product that is the result of this step of chemical manufacturing process, because I don't actually know the chemical structure of the product yet, but I know how to make it. And that's sufficient, I think, for that chemical, because I'm actually trying to identify and define that chemical, not any possible chemical that might result.
I know I said I want to address the guidelines, but I'm going to diverge a little bit from that for a minute. I think that what I see is in the bio space where people aren't used to 112F and they're saying, that's not what we typically see. They're more accustomed to the policing feature being under the other parts of the statute, 112A, 112B, et cetera. And I've been on panels where we have people in the bio space suggesting we should be more invoking 112F in the biospace, and we've had other people saying, no, absolutely not. But I do see that there's probably more in the high-tech space that needs to be done in 112A and B, and possibly more in the bio space regarding 112F. I do think they're all very related and interplay.
And now, since we deprived you of your ability to defend the integrity of the guidelines, we should let you do that.
No, rather than defend the integrity of the guidelines, I would just like to explain what we've done and what we are, what our approach has been. So obviously there are people, you've heard it here, that would like us to go further than what we believe the case law says, and our intent is to not do that. Our intent is to train examiners and to give guidance that is consistent with the case law. I do believe that the Packard case, the Apple v. Motorola cases show that what we've been doing is very consistent. But what we've really tried to do with training of examiners, and this does get back to the White House executive action with number 2, which is all about tightening scrutiny of functional language, is we've really attacked that by saying we want our examiners to, one, very consistently apply the laws. So we've gone back and have started review training for the entire Corps on various areas. And we're in the middle of that now, so it's still going to continue. We started with the 112F area and have a number of training modules on that, and I'll discuss those in a minute. But we've also really focused on examiners being clear in the record. And if you walk away from here remembering anything I've said, I'm hoping that's what you will remember. Because while we know people would like us to go further, we believe it's critically important for those examiners, for our staff, to be very clear of what they are intending, how they are interpreting a claim. So in other words, if they are interpreting a heuristic, right, and to invoke 112F in a certain situation, we have trained our examiners to say that, right? Conversely, if they're not saying heuristic invokes 112F, depending on the facts of that case, we want them to say that as well. And our goal here is so that the applicant can at least have a better understanding of what the examiner's position is, so that they can have that discussion. And they can have that discussion during prosecution when there can be changes to the claims. There can be that back and forth that's needed to make sure those claims have sufficient clarity.
Okay.
So,
sorry.
No, go.
Can I ask
Absolutely.
whether you think that the decision to invoke 112F is the applicant's decision, or is it in fact sort of a legal decision? Is it can the examiner look at this and say it's got no structure, therefore it's a means plus function claim? No,
I absolutely believe it's a legal decision. I don't believe that the applicant can say I intend one way or the other, and that's what the record is bound to. That being said, the examiner has to make that legal call. We want the applicant to know what the examiner's call is, so if the applicant disagrees, they can have that discussion. The examiner may or may not change, okay, but at least they're having that discussion. And to the extent the examiner doesn't change, and that's not what was intended by the applicant can amend the claims. So I think there's the clarity aspect is very, very important, very critical, we think, and that's what we are trying to push, is that examiners are being clear. The worst case scenario, as I can see it, is the examiner has, an interpretation of the claim. Maybe the examiner interprets a claim, invokes 112F, and therefore gives a more limiting read and says you're looking at the spec or the equivalence to define a term or a phrase, and then the applicant thinks it's not. They go through a prosecution entirely missing each other, right? The examiner issues the case, because in the examiner's mind, it was more limited than what the applicant had. Case issues, the applicant's going to go out, and of course they're going to assert that to the level that they believe they were entitled to. And if they never had that meeting of the minds with the examiner, to me that's the biggest failure. That's a process failure of the system. So that's what we are trying to do away with. What we have done so far, we started with 112F. Although I will tell you, back in 2011 was the real start of this, where we had a Federal Register notice with addressing 112, all of 112 and functional language. But we have recently started with training examiners on various modules of 112F. All of these are available on our website. What we've done is we started with just a basic review about how to identify when you have a 112F limitation, so that examiners would be applying this consistently. We then came out with a module about how to clarify the record. And what we did is basically relied on the legal presumptions that arise when you either use the words means or don't use the word means, and have examiners saying when those presumptions are overcome, they are clarifying the record so that if there's a situation out of what would be typical, the applicant will know that. Our third module, which we've just completed, was about broadest reasonable interpretation and definiteness when there's a 112F limitation. We are soon coming out with, most likely either starting at the end of this month or the beginning of next month, a definiteness of software limitations, and we'll have a number of examples of Federal Circuit cases and when is an algorithm sufficient. And I do believe, I am expecting that will help a great deal, because I think whether you need an algorithm and when you need it and when it's sufficient is a big issue. And then there are plans for continuing on with 112B, 112A, even just broadest reasonable interpretation in general. So we expect this to go onward, hopefully forever, right? And just being continuous improvement for the examining staff. And again, I just want to point out, you go to the USPTO website, and everything is made available so that you can see exactly what the examiners are getting trained. We're putting everything in a CBT format so that you can see exactly what we're telling the examiners.
Great. Perhaps one more question for the panel before we open it for the audience. This may be wishful thinking on my part, but I like to think that the functional claiming jurisprudence fits the pattern that Mark alluded to earlier, where the Federal Circuit has applied some pretty rigid rules that don't find a lot of support in the statute. Is this an issue you think will go up, and what would happen if it did?
I think it will go up eventually when it's teed up nicely. Maybe Apple versus Motorola is the case that tees it up nicely. I think, well, the Supreme Court has never interpreted Section 112F. It was added to the statute in 1952. I think if and when they get this case, they're going to read that statute, which says you can claim you can use functional language without the disclosure of structure, means, or acts in support thereof. And if you do, it is interpreted, we read this, we limit it to the specification and equivalence thereof. They're going to read that and they're going to say, nothing in that language says you got to use the words means for doing X. The relevant question under the statute is quite clear. It's, is there structure in the claim? If there's structure in the claim, not means plus function. If there is not structure in the claim, it is means plus function. And this sort of rebuttable but less and less likely to be rebutted presumption that we're seeing at the Federal Circuit, is a creature of Federal Circuit law developed over the last 20 years, and it's just not consistent with the statute as applied in a case like Apple versus Motorola, where there just isn't any structure plausibly in the actual language of the claim. So yeah, I mean, I think honestly, I guess I would say two things, right? One is I think as this issue is getting noticed and as it's being litigated, it is going to come to the attention of the court eventually. A case like Apple versus Motorola, where there's a strong dissent by Judge Prost on this question, might be the case that draws that attention. But even if it's not, it'll happen at some point. I also, to tie us back to the first panel, I guess I have to say, we'd be in a much better world if we had this case and not Alice versus CLS Bank as the case in which the Supreme Court intersects with software, right? Because I think one of the things that the Supreme Court is responding to with its 101 jurisprudence is this incredibly broad functional claiming of software, right? The fact that I'm not actually tying these claims to algorithms, to particular ways in which I solve the problems. And that naturally inclines the court to say, that can't be patentable. That sounds like an abstract idea. I think abstract idea is not a great way to get at that problem, right, for some of the reasons we heard this morning. We'd be much better off in a world in which the rule was, if you write those kind of broad functional claims, we're going to interpret them as limited to the way you solved the problem or other algorithms like it. We're going to narrow those software patents to something commensurate with what you actually invented. And as narrowed, they don't present a patentable subject matter problem. They're not claims to an abstract idea any longer. They're claims to a specific solution to a specific problem. So that's, I complained about wishful thinking on the last panel. That's my wishful thinking, and I acknowledge it for what it is.
So I'm not a seasoned Supreme Court watcher like Mark is, but I have to think that, with some of the cases that they've taken, like CLS and like Nautilus, they take the case because they recognize that there's an issue, and then when they start digging into it, it maybe isn't exactly the issue that they thought it was, and they see some. I think that they perceive that there are some overall, functional problems with the patent system, and my speculation is that they still, haven't quite found the right hook yet, and when they look at a functional claiming case, what I'm hoping that they'll see is that it's a separate problem than the ones that they've treated already. That you can have a claim that is clearly patentable subject matter and indisputably under 101 that is as clear as a bell and doesn't present a problem with the earlier paragraphs in Section 112, yet nonetheless is claimed in a functional way that leads to an overly broad patent and isn't readily limited by the other doctrines, and I think that's a real opportunity for them, and I don't see any reason why the Motorola v. Apple case and the very excellent dissent in it wouldn't be the right opportunity.
It is even conceivable that we'll hear something this term that bears on these issues, right? So the Nautilus versus Biosig case is a functional claiming case in some sense, right? And the patentee's interpretation, it's, place the electrodes anywhere that works. You could look at that, and one of the petitioner's subsidiary arguments, although it didn't get much airtime in the oral argument, was, hey, that's functional claiming, but it's also notable that in the Alice case, Justice Sotomayor actually asked about functional claiming, and isn't this patent just really claiming the function and not the particular solution? So it's it's conceivable, though I suspect unlikely, that we would get some guidance on this area from either one of those cases in the next month.
Yeah, well, I think those are both extra indicators that there is a hunger to address an issue like this.
Yeah, I would only add to that unlike the prior panel on 101, this is not new law, right? This 112F and how to handle functional language, at least in my opinion, is not new, but it certainly is getting a lot of recognition, and people are understanding how many gray areas there are in how you apply what seems to be a law that has been around for some time.
Great. With that, I think we have about 10 minutes left. Shall we open up for questions from the audience? Yes.
So the question is, are there kind of something that's in between nothing and a patent that might avoid some of the problems with this patent but also give a lesser term of protection? So in the United States right now, the answer is no. I mean, I guess in one sense you could consider trade secrecy, depending on the industry you're in, to serve some of that role. But it's got a very different set of characteristics. There are countries that have so-called petty patents, which give less significant rights and for a shorter term, and which also have a less detailed examination in the PTO or equivalent. And so there's been some proposals, and I've actually participated in a National Academy of Sciences study relating to synthetic biology. And one of the issues that they were faced in synthetic biology is, well, how could we give appropriate protection to kind of small sort of sub-organism created DNA sequences that perform particular functions? We'd like them to have some protection against copying. We don't want to grant patents on each of these little pieces because you're going to need to assemble them all together to make a functioning synthetic biology organism. And so one of the things that we actually talked about was whether there ought to be something like a petty patent system that would prevent copying of these things, be easier to get and cheaper, quicker to get, but which wouldn't have the sort of broad rights to stop anybody from doing anything that had this sequence. So right now, I think the answer is no, but it's probably not a crazy idea.
Are not plant patents a part of the answer?
Plant patents in the so we got two different types of plant patents. We got plant patents, and we have a sort of quasi-patent, the Plant Variety Protection Act, that protect different types of plants. And so if your invention is a plant, then I think there are some hybrids in that respect. That's right.
Yes.
So I've got a patent here that I was looking at, and I want the panel to opine on whether they think this will satisfy the Supreme Court's indefiniteness standard when it advances and it's a new telecommunications technology. And the basic insight into this is the way you put sort of vibrations on a wire is you put magnets near the wire, so the claim language discloses that and then uses the following language to say how close things have to be to the wire, how close the magnets have to be. And the claim language is in the neighborhood. And now some of you might have guessed that this is Alexander Graham Bell's patent. So I'm kind of wondering, now that I've read that patent, I think it's kind of a famous patent, is in the neighborhood definite?
Yep. Yeah, right. Ask Mr. Rogers.
That's right. I mean, I think
so,
I'm in the neighborhood of my neighbor,
yep.
my colleague, who's about 500 yards.
Well, yep. That's right. That's another problem. So, John, I think the answer is it's a close question. And well, no, it shouldn't shock you for this reason, right? Alexander Graham Bell's patent is iconic. But it was extraordinarily controversial at the time that it was issued, right? In the following two senses. So Elijah Gray files an application for a competing technology on the same day, and he's actually further along. Bell's a bit of a paper patentee at the time. The US Patent Office goes to the extraordinary length of petitioning to cancel the Bell patent because they decided that it was wrongfully issued. That case is consolidated with the infringement case that Bell brings against a competitor. It goes to the US Supreme Court. The result fills an entire volume of US reports and is split 5-4. None of which is to say, right, Bell turned out to be the victor of history in this question, right? But it's far from clear that, well, of course, this is a patent we should have granted in those terms. Now, that said, I think that the court is going to say spaced apart is just fine as long as people of skill in the art know what it means, right? That they understand that it's more than an inch or so that because the hands can't be too close together or you get interference, and that it can't be too far away. I think they would say in the neighborhood is fine, not because it could mean anything, but because a person of ordinary skill in the art in this field will know that it means this little gap, but not more than that. I think that's probably the right result if it is in fact true that a person of skill in the art would know this thing. And that raises a point actually that we didn't talk about in the panel, but that is worth talking about. If this is the test the court articulates, and I think it's likely to be some variant of that test, I don't see how you can square it with the conclusion that indefiniteness is a pure question of law. If the only thing that's going to determine whether or not a claim is indefinite is what does the person of skill in the art think, that sounds like a purely factual question to me. Now, That said, obviousness is a question of law, and that often seems to turn on what the person of skill in the art thinks, so maybe the court can thread that needle, but it sure sounds like a corollary of that conclusion ought to be this is either a question of fact or it's at the very least a mixed question of fact and law. You got Judge?
I have a question. You seem to indicate that an examiner might opine whether some claim limitation comes under 112F. And I don't see why that should be the case if the claim passes 101, 102, 103, 112, descriptive. I don't care what the examiner says, because even if the examiner is correct or incorrect, that claim is valid. And that should be enough. I don't want the examiner giving an opinion about, whether the claim should be more narrowly construed or not. I don't see that's very helpful.
Well, so, but
It doesn't help the person of ordinary skill in the art who's supposed to look at the face of the patent
And the prosecution history.
The scope of the claim, unless if you are saying that that person has to have an attorney sit there and review the file wrapper and then try to determine whether an examiner's dictum is relevant.
So the problem I have with that is that I think that it's not going to be the case that the 102, 103, 112A and B inquiries are separate from this inquiry. If your claim covers this, it's a means plus function claim, and so it covers only this particular structure and equivalence thereof, it might be that there's no prior art that covers it. Might be that you've enabled it and given it written description. But if take the same claim and say it covers any possible means of doing this thing, well, then now I might tread on the prior art. Right? Now I might turn out not to enable it or provide a written description for it. So I can imagine a case in which this is true, but it's often...
But just for no good reason, I've never seen the examiners, sit down when they examine a case, come up with art. First say, I interpret your claim this way. Because if they do, then they have to look at the specification, and try to interpret, the scope of the claim, and then go for art. I mean, maybe sometime down in the bowels of the, prosecution, as you get in, if it's difficult or whatever, sometimes it becomes relevant. I'm not saying it doesn't, but for no good reason, unless it becomes relevant, there's no point to having that examiner's, as I said, opinion, because very often the courts look at what the examiner writes as reasons for allowance, and they say, interesting, but hell, we'll make our own determination.
So I take the point. Although I think, to me, the fact that we're not actually willing to do anything to talk about the scope of the claim or claim construction in the PTO historically is actually one of the reasons claim construction is in such the mess that it's in. Right? It's one of the things that's gotten us into the problem.
Can we?
No, I understand, but if you're having different standards in the patent office and in the court system, now I get a patent. You don't sue on every one. What you like to do is have claims that are clear enough, strong enough over the prior art that someone would look and say, yeah, I need a license, et cetera, without having to sue. If you have gratuitous statements that might be disregarded by courts later, it harms the strength of the patent. It hurts the patent system, in general. It hurts the clients who are who are paying for it and trying to get patents for the reasons that people do without, lawsuits. Get the value for it. Because everybody, as you know, in a negotiation is always looking for a reason to, hey, examiner thought this was very narrow, therefore I can see that I don't infringe, et cetera, makes it more difficult to get less value. I mean, part of the system is not just to say...
I'm trying to wait for a pause here so I can go on to another question. One more question before we're done.
Oh,
yes. All right. I think with that we're adjourned for lunch.